Good afternoon, everyone. Welcome to our talk on the lasting power of attorney. Today, we have Ms. Au Kin Kit with us. Kit will share with us what is a lasting power of attorney, and she will also share with you how you can prepare one yourself. This talk will be primarily in English, and I will summarize some key points in Mandarin along the way. You can type your questions in the Facebook comment boxes, and we will try to address them towards the end of the show. Over to you, Kit.
Thank you so much, Yuan Fei, and good afternoon, everyone. Today's talk is probably held in one of the situations which is also quite new to me, having a webinar of sorts, and also because we are in very special times, and I hope everybody is keeping safe. So today, what we want to talk about is also a topic which I feel many of people like me in our middle age and some others in the silver generation, which I am also fast approaching, I think, would be very interested to know and concerned. So planning ahead, lasting power of attorney. Many of us may be thinking, we've heard so much about the LPA. What is the LPA? So the lasting power of attorney, or commonly known as the LPA, is something that I think most of us in this particular age range will be interested and concerned about doing. Today's talk, is specifically about telling you about what this is about, and also how do you go about making an LPA and registering an LPA, and also why is it necessary for you to have an LPA so that if something were to happen, you still have people making decisions for you. The first part of this talk, I will go through some slides that will tell you what it is about. And then the next part of it, we will go into the nitty-gritty about the procedure, how you fill out the form, and also if you have any further questions, who do you go to and how do you find out more about the LPA. So without further ado, I will tell you a little bit more about what is an LPA and what it is for. We always say that, it's so easy to die. Dying is actually not the difficult part. It's what if you don't die? And, if you want someone to help you when you are mentally incapacitated, will you know what to do if you don't leave, the necessary instructions or tell who it is to help you in situations like this? Now, for you to appoint someone to act for you for your personal welfare, property and affairs, in the event that you lose mental capacity, is the purpose of why you should make and register the LPA. Now, your next of kin, for example, your children, they do not necessarily have the automatic right to act for you when you lose mental capacity. Now, when we talk about when we say that when you lose mental capacity, what are some of the typical situations? And I think many of us would have seen situations happen like this. For example, you can have a stroke, you could have dementia, you could even fall into a coma, right? These are situations whereby you will lose mental capacity. And when things like that happen, it doesn't mean that, oh, my son will take care of me, don't worry. My daughter will make the right decisions for me, I don't have to worry. It's not something so simple because, as I said, the next of kin doesn't have the automatic right to act for you even when you lose mental capacity. And if you don't have an LPA, they actually have to go to the court to apply for a court order in order to act for you. Now, surely you don't want to put your next of kin to such inconvenience. And therefore, this is the purpose of why you should register for an LPA. So who can register for an LPA? Now, today we're talking about you. You are the donor. You are the one who will decide that you want to make and register an LPA. So what do you need to fulfill in terms of the main conditions? In order for you to register an LPA, you must first be at least 21 years old. You must not be an undischarged bankrupt. And most importantly, you must have mental capacity. Seriously, the situations I talked about, having a stroke, having dementia, having a coma, we really don't know when we will lose our mental capacity. And therefore, I guess to share with you is do not delay, do not procrastinate. You should get your LPA registered. And this will actually help you a lot. And also your next of kin and the people who care for you, who will know what to do when you do lose mental capacity. So there are some other situations, and I would just want to touch on this very quickly before I go back into the so-called the mainstream of the discussion. What if I have children with intellectual disability, who is going to care for them? You might think of that because, they may be young now, but someday they are going to be 21 years of age. And that's where you will have to start to wonder, they may lack capacity. So what happens? In situations where you have children with intellectual disability, you may apply to the court to be appointed deputies if the children are likely to still be lacking in capacity after reaching 21 years of age. You may also apply to the court to appoint successor deputies as future decision makers. If, for example, you fear you will go, as in you will pass away before your child, in the event that you are no longer around and you are unable to make those decisions for them. So this is sort of a special situation. Now we go back to the LPA now. When will the LPA take effect? Now, after you lose mental capacity is when the LPA that you have registered will take effect. Now, mental capacity is typically certified medically by a doctor to say that you have lost your mind. It's not something to say, oh, you're a mad person. Have you gone out of your mind? Have you gone nuts? It's not like that. It is a somewhat more formal process. And I think it's important for us to understand why it's necessary sometimes for it to be certified by a medical professional. It's because when you have the LPA registered, you may go to, say, a bank or an institution when the donor loses capacity, and you go with, let's say, and these days it's like a soft copy as well. When you bring it to third-party institutions, they may say, oh, but I also additionally require to see a medical certification of the loss of mental capacity. Now, this is something, therefore, this is what I feel you should also obtain. Besides registering your LPA, your caregivers or your donees would also want to obtain a certification by a medical profession. Now, I'm going to go into what are the procedures and what are the steps that you need to do or to take in order for you to make an LPA. And if you see the screen now, you will see 4 boxes. I think it's in lilac color. And these are, to me, the 4 important steps, very basic steps. And you just have to remember these 4 steps. How do you go about registering an LPA? Now, firstly, you have to fill up the form. Now, the form is obviously the most important thing because that's the starting point. All right. So you fill out the form, and also your next step is to get it signed. Because if you don't get it signed, as in you, the donor, your donees, and the certificate issuer will have to get it signed. The certificate of issuer will either be a lawyer who is an advocate and solicitor that have a practicing certificate, or a medical professional that is registered with the Office of the Public Guardian, or a medically qualified psychiatrist. Now, these are the certificate issuers. Now, all 3 parties, or there could be more if there's more than one donee, will have to sign the form. Now, the third step is once you get the form signed, you have to mail it to the Office of the Public Guardian, or for short, OPG, for registration. Now, don't forget to also attach a copy of your NRIC if you are a Singapore citizen, or if you are a non-Singaporean, you can also attach a copy of your passport. It's important to attach that because otherwise your submission is incomplete, and then the OPG will not be able to process it for you. Now, when the OPG receives the copy of your passport and the form itself, it will be registered if there are no objections after the mandatory 3-week waiting period. Now, that's your 4th box where you will see the 4th step is it will be registered if after 21 days of that waiting period, there are no objections. So remember again, these 4 steps. Fill out the form, get it signed, mail it to OPG, and wait for 3 weeks. If there are no objections, it will be registered. So now on this new slide, and some of you may have heard, oh, wow, LPA got Form 1, Form 2, what do I do? Well, very simply, there are 2 forms. Form 1 is a more basic form, and typically it satisfies most of what the majority of us need to do because it's not so complicated. And you only know who you want, you already know who you want to appoint as donees, and your assets, your personal welfare, very simply can be covered by Form 1. So that's the first option. Now there's a slightly more complicated Form 2, and that's where you need a lawyer to draft for you. So remember, in Form 1, you don't really need to have a lawyer to draft it for you at all, but Form 2, you must have a lawyer draft it for you. Form 2 is for donors who wish to appoint either more than 2 donees or more than one replacement donee, or you have very specific needs and you want to grant specific and customized powers to those donees which you cannot address them in the Form 1. So remember, Form 2 is if you have these specific needs, or you have more than 2 donees or more than 1 replacement donee. If that's not your situation, then you just go back to Form 1, which is the very simple basic form. And as I said, most of the time, Form 1 will cover the majority of our needs. The forms, both of them, can be downloaded from the official website of the OPG, which is the Office of the Public Guardian. And you can actually access their official website to have a look at these forms in your own time. Now, fees. Now, aren't we all always concerned about fees? Is it very expensive? How much will it cost? Should I do this? Do I have enough money? Well, the answer is, if you're only looking at LPA Form 1, which is the most basic one, you want to get it done and registered, here's the good news. For Singapore citizens, it's free, so there's no money involved. And originally, the fee of $75 is waived for another 2 years until 31st of March 2021. Well, actually, it's about one year, more or less. So there is time for you if you want to make use of this period of time. So if you're a Singapore citizen, you want to file and register Form 1, it's free for you until 31st of March 2021. Now, if you are a Singapore citizen, but you want to file Form 2, or if you are PR, or if you're a foreigner wanting to file either Form 1 or Form 2, then if you look at the slide in front of you, there will be a small fee that you will have to pay in order for you to get them registered. So don't forget, March 31st, 2021. Do it before then. If you're a Singapore citizen and you want to file Form 1, it will be free. So some of us may be wondering, okay, after I filed and I registered my LPA, hey, what if I change my mind? And there are obviously situations which may cause you to change your mind. Can you cancel it? Can you revoke it? And the answer is very simply, yes, you can, but you must make sure you still have the mental capacity to revoke and cancel the LPA. So yes, even if you register it, you can still have an opportunity to cancel or revoke it as long as you are not mentally incapacitated. Now with this, I know I've said a lot. I want to now hand over to Yuanfei, who will actually do a little translation and to give the benefit to our Mandarin speakers. So Yuanfei, I'll hand this over to you now to give a Mandarin translation of what I just said.
Okay, thanks, Kit. I'll just do a little bit of a summary in Mandarin of the key points. Okay, 欧律师提到了几个重点。第一个就是要在您有心智的时候立持久授权书。第二个重点就是，如果你选择了1号表格，你不一定要律师去草拟这个表格，只有第2号表格才需要律师草拟。第三个重点就是，表格填妥后、签名后，你要寄给公共监护人办公室，然后你要等了3个星期的等待期后，你就可以注册这个表格了。Okay, over to you, Kit.
Thank you, Yuanfei. Now, so next, I'm sure many of you must be wondering, so what is Form 1? How does it look like? Is it very complicated? Is it something which, we will find it very difficult to complete? The answer is no, it's actually a very simple form. And I will now put on the slides on your screen, you will actually see how the Form 1 actually looks like. If you look at this particular slide, you will see that I've reproduced the Form 1, which is the 2020 version that's officially issued by the Office of the Public Guardian, which is the OPG. Make sure that you have the official forms because it is important for you to use the official form and learn all you need to do and read all the important information before you complete it and before you register it. So this is page 1 of the form, which is basically a lot of information that you should be familiar with. Now you may be asking, wow, so many words. Is it so, wow, what should I pay attention to? Firstly, do see that you can see from the cursor here, I have actually circled 2 things. Now there are powers that you will need to give to your donee when you become mentally incapacitated. And these powers are actually split up into 2 different types of powers. You may want your donee to help you with, firstly, personal welfare. Personal welfare will be where you live, day-to-day care decisions, who do you have contact with, healthcare, and so on and so forth. Now, property and affairs is the other part that you should read, because in this particular section, you will be allowing your donees to help with buying and selling of your property, operating your bank accounts, etc. So these are the important things you should read from this page. Now, secondly, you also should know that in order for you to submit the LPA Form 1, where are the relevant details and where you should actually be providing the Form 1 after you have completed it and after it has been signed, and where you need to submit it together with a photocopy of your NRIC or your passport, as the case may be. Now, last but not least, in this page, you will also see if you want to cancel or revoke your LPA, there is a link here in which you can actually download the revocation form. This is also important because you may want to decide to cancel it, and therefore you should take some time to read this page carefully. The next page, which is page 2, is actually very simple. You can just actually see it on this one page. Is you, the donor. The person who wants to make and register the LPA is what we call a donor. And the donor will have to fill out his or her particulars very simply at page 2, where you have to complete your full name, insert your NRIC or passport number, your date of birth, your email address, and your contact number. Please also provide a local mailing address on this page. And you will also see that at the bottom right-hand corner, signature of donor, and it appears both in all of the pages. Please make sure that you initial on all these pages, because otherwise the form will be incomplete. I'll move on now to donees. So remember, we said earlier that you who want to make the LPA is the donor. Now, who are donees? Donees are the people whom you decide to want to give the power to act for you in the event that you become mentally incapacitated. So who are donees and what can they do? What do they do? So I will take you through that in a short while. But before that, let's do a little bit of revision. Okay, I said donees can help you in two main ways. The first one is in the aspect of personal welfare. And you looked at that from Form 1 just then on page 1 of Form 1. So again, just to recap, if you are mentally incapacitated, your donees will help you decide where you live, your day-to-day care decisions, what do you wear, what do you eat, and handling your mail, your letters, who you may have contact with, because when you're mentally incapacitated, you will want to trust someone, and the donee will have to help you make those decisions. And last but not least, under personal welfare, your healthcare and your medical treatment decisions. And those are actually very important decisions because they concern your personal welfare. And obviously, if you are mentally incapacitated, you have to trust someone to make those decisions for you. Now, on the right-hand side of the slide, you will see property and affairs. And these will include things like your property, buying and selling of property, renting, mortgaging your property. Some of you may have more than one property. You may have many bank accounts, and you will have to trust your donees to act on your behalf once you are mentally incapacitated. For example, operating of bank accounts, withdrawing money so that you need for your basic needs, managing your CPF monies, paying of household expenses. Because if you don't have this and your donees are not able to act for you, then many a time your monies could be stuck and they cannot be taken out for use appropriately that you require for your daily needs. And last but not least, under property and affairs, another good example is purchasing any equipment that you may require in order for you to live your daily life. So these are, again, just an elaboration of what you would have seen in page 1 of Form 1. Now, who can be your donee? Remember, a few slides ago, I said we were talking about next of kin. And many of us will think, we take for granted, right? Oh, I will die, it's okay. As I said, dying is okay. So, oh, I won't die. But even if I'm no longer mentally capacitated, if I'm mentally incapacitated, my son will take care of me. My daughter will make all my decisions. Oh, don't worry, don't worry. But actually, I think you should worry because the LPA gives you this particular opportunity to set things, formally, and also decide who should be your donee. Now, donee can be professional or non-professional. Remember, Donees are the ones who will make the decisions for you if you lose your mental capacity. Who is a professional donee? Now, professional donee are the ones that you can actually appoint, and you pay them some fee or remuneration so that they can act on your behalf. A professional donee can also be a licensed trust company. However, I want to highlight that if you use a licensed trust company, then the LTC is only allowed to manage your property and affairs, and they cannot actually deal with your personal welfare. Now, those are the professional donees. Remember, if you use them, you have to pay them a remuneration. Now we look at non-professional donees. Who are non-professional donees? Right? Instinctively, you will know that they are not professional donees, but they can actually be your children, right? Individuals who act as donees without remuneration, typically, and they must fulfill certain conditions in order for them to qualify as individual non-professional donees. Firstly, they must be of age, which is 21 years old. They also cannot be an undischarged bankrupt. They are only allowed, I beg your pardon, they are allowed to manage both your property and affairs as well as your personal welfare. So a typical non-professional donee would be your children, people you trust, your best friend. These are people whom would qualify as non-professional donees if they fulfill those conditions. Now, I know I've spoken a lot again, and I will now hand back over to Yuanfei, who will very capably do a Chinese translation. Yuanfei, please.
Okay, thanks, Kit. So just now, Kit has mentioned quite a few points. I'll do a summary in Mandarin. But before I do that, I just wanted to highlight this terminology. She's spoken a lot about donee. So in Chinese, if you hear me using the term 被授权人, that's donee. So with that, I'll do my translation. So I think the first major point, 第一个重点就是持久授权书覆盖2个范围。第一个范围是个人福利，另外一个就是产业与财务事宜。所以你在这个持久授权书里面呢，你可以选择2样，或者是其中的任何一样。第二个重点就是说，您可以选择您的朋友或者你的至亲来当您的被授权人，你也可以委任一个专业的被授权人。Okay, that's my little summary. Over to you, Kit.
Thank you so much, Yuanfei. So, having given you the background and the context of who can be a donee, who are donees, I'm sure now you will be quite interested to find out a little bit more about, how many donees can you appoint, and also, who can qualify, why do I need a replacement donee? So now in the next few slides, I'm going to take you through those details. And I promise you that this is probably going to be the slightly more complex part of this webinar, but bear with me because it's very important. You need to know how many donees you should appoint and why you should have a replacement donee in certain situations. Now on this slide, you will see that you must, under Form 1, minimally appoint at least 1 donee. And under Form 1, you can also appoint up to 2 donees. And also, you can appoint 1 replacement donee in the situation if you file Form 1. So I repeat, you must appoint at least 1 donee, but you can have only a maximum of 2 donees. Under Form 1, you can also choose to appoint 1 replacement donee. The maximum number of replacement donees under Form 1 is 1. Now, why do you need a replacement donee? Typically, and if you look at this slide, the replacement donee replaces the original donee in the event of certain situations. For example, your original donee may no longer want to act for you. There could be many reasons, right? Life happens. Now, your original donee may also himself or herself become mentally unsound. Thirdly, your original donee could predecease you. They could pass away or die before you. Now, the original donee, if your original donee is your spouse, situation could happen whereby you are divorced and you may not want, or he or she may not want to remain your donee. And last but not least, your original donee could himself or herself become a bankrupt. So that's a situation whereby you should want to have a replacement donee come in to take the place of the original donee. In the next slide, which you see in this very colorful thing, I'm going to bring to your attention a few scenarios. And it talks about the manner in which your donee can act, right? So if you appoint only one donee, as you can see in the top of the slide, then you only have one person acting for you when you lose mental capacity and when the LPA kicks in. Now, I repeat, if you appoint only one donee, then he or she will only be the sole person acting for you. If you feel that this one person may not always be around or available, then you may want to appoint two donees. So if A is not around, B can act for you. Or if B is not around, then A can act for you. This is what we call joint and several donees. And you can see that in the middle of the page, or middle of the slide. You can see that, when you feel you want to have two donees, because, for example, you may say your son or your daughter, maybe my son is never around, he's overseas or whatever, and you can appoint so-called joint and several donees so that if your daughter is here and she's available, she can also make the decision for you. Now, if you feel, no, I think I need both of them. I need two donees to make decisions for me all the time. And if you feel that these two persons need to discuss and make a decision, then you can appoint what is the third scenario at the bottom of the slide, known as joint donees. However, and I want to highlight this because it can become a very common situation, you will need to note that if these two people cannot come to an agreement, then no action can be taken. Then honestly, there's no use for your LPA if a situation like that takes place. So again, these are the three scenarios which you want to consider carefully before you decide to appoint donees. Now, so this slide basically again summarizes what we talked about before, why you need a replacement donee. So I'm not going to repeat it. So you can read for yourself the examples whereby the replacement donee can come in to take over. There are various ways that you can appoint donees, but for Form 1, again, this is a recap. You keep within the maximum of 2 donees, and you can have also a maximum of 1 replacement donee. This very nice and colorful slide again basically tells you that you can appoint up to 2 donees. For example, and I'm going to give them names here. You can appoint Mary and David for personal welfare. All right. And so if you do this, then you cannot appoint Mary and David. I beg your pardon. If you appoint Mary and David for personal welfare, and you actually also appoint Mary and David for property and affairs, so that's fine. But you cannot have Mary and David for personal welfare and then 2 other people, let's say Susie and Charlie for property and affairs, because that will mean you end up having 4 donees, and under Form 1, you cannot have that. You can still only have to stick to 2 donees. So basically, if you appoint Mary and David for personal welfare and Mary and David for property and affairs, that's fine. That's the first example. Okay. Now, basically, if you look at the examples 2 and 3, it also shows you some other permutation. For example, you can appoint Mary for personal welfare and also David for property and affairs. That is also another possible permutation. And last but not least, you can also appoint Mary for personal welfare. Let's say Mary is your daughter and you feel that you're more comfortable with Mary handling your personal welfare, that's fine. And then for property and affairs, you may say you want Mary or Mary and David, who is your son, to deal with personal, so for your property and affairs. That's also another possibility. So this slide basically gives you some examples. We're not saying that this is exhaustive, but what we are saying is that these are some of the possible examples that you can consider in order for you to when you are making a decision on who you want to appoint as your donee. So I gave you a quick introduction of what is a replacement donee. Now I want to show you an extract from the form itself at page 5. So if you look at page 5 of the form, you'll see that the replacement donee is not quite the same as the original donee. Remember, we said that a replacement donee steps into the shoes of the original donee when the original donee is not able to act on your behalf anymore. So, for example, if your Donee, original Donee, is not in Singapore, then your replacement Donee, let's say the original Donee is not in Singapore for 2 weeks. Your replacement Donee cannot come in and replace him simply because he's not available for 2 weeks. Now, the replacement Donee comes in only when your original Donee can no longer act. And I believe we have already covered that, those examples of situations whereby your original Donee is not able to act. So you then need to decide, how do you replace your original Donee? And this extract from page 5 of the form is important because you need to tick, how will your replacement Donee replace the original Donee? Now, if you look at the two highlights, the yellow one and the green one, I will just tell you that the one that I've highlighted in yellow is really the most straightforward. Basically, any original Donee who is unable to act, your replacement Donee can just step into his or her shoes. That is actually extremely simple, and that's something you may want to consider, because then you can be rest assured that in the event of the unavailability of the original Donee, then the replacement Donee will just step into his or her shoes. Now, of course, you can say, okay, I want to be more specific, and it becomes a little bit complicated, because if you say that your replacement Donee, and don't forget, under Form 1, you can only have one replacement Donee, will step in only if Donee 1 is not available. Then, if that happens, then I feel it's unnecessarily, it's a bit too restrictive. Because, for example, if Donee 1 is only allowed to be replaced by the replacement Donee, then what happens later if Donee 2 is the one that requires to be replaced and not Donee 1? Then you are sort of stuck. So again, just to reiterate, I feel that leave it as flexible as possible, so that in case one person, as your original Donee, is no longer able to act, then at least your replacement Donee can immediately fill the shoes. So don't forget, it is something that you don't want to get too complicated. And this is really another slide that gives you the summary. Now, if you look at this slide, I just want to highlight again, it is your choice how you want to appoint the Donees. And from the information that I've provided to you in the slides before this, you will note that you can have joint Donees in an and situation, meaning 2 Donees have to agree before any action can be taken, or you can have a joint and several Donees situation. That happens when one Donee cannot act, the other one can step in to act on his and continue to act on your behalf. So again, to recap, it is also your choice how you wish to appoint replacements. But as I said, don't make it so restrictive until it doesn't make your LPA work. Your LPA needs to work for you, and therefore you should choose the most unrestrictive, most flexible way in which your Donees can act on your behalf when you become mentally incapacitated. So again, that was a whole lot that I've spoken about. And now I'm going to ask Yuanfei to do a Chinese translation for the benefit of our Mandarin speakers. Yuanfei, please.
Okay. Yeah, thanks, Kit. Again, a little summary about that. So,欧律师也是提到一些重点，对不对？第一个重点就是说，如果你要利用1号表格，你最多可以委任2名被授权人，而且如果你选择要委任2名的话，有2种方法。第一个方法就是两者之间任何一个人都可以行使他的决策权，我们英文就俗称说 joint and several Donees， 两者之间任何一个都能行使决策权。第二个方法就是说，你如果委任2名被授权人的话，这2名一定要一起行使这个决策权，如果他们不能达成共识的话，就不能行使决策权。所以我们英文俗称这是 joint Donees。那在 joint and several Donees 跟 joint Donees 之间呢 ，joint and several Donees 会比较有灵活性，因为在某一个时期，你只需要一个人去行使这个决策权。如果一个人不在，另外一个可以执行；这个不在，另外一个也执行。
谢谢Yuanfei, thank you.
I think that's my little summary. Oh, sorry, I think I need to summarize on the replacement Donee as well. Okay. 然后我们刚才我们有谈到替代人，对不对？因为世事难预料，对不对？所以如果有一些被授权人因为死亡、破产、离婚等原因无法继续当您的被授权人，你可以预先在 持久授权书里委任另一名人来代替。为了不让替代有所障碍，你应该尽量在表格里选择 any donee who is unable to act， 就是说这个人可以替代任何人，而且是任何事物。Okay, over to you, Kit.
谢谢袁飞 ，Thank you very much. And now I think it's a good point in this webinar for us to look into some of the other pages of the form itself. So we looked at page 1, we looked at page 2, we looked at page 5, and now since we were on the topic of Donees, I think it's important for us to also take our audience through the pages that are relevant to the Donees, so that when they fill out the form, at least they have some mental preparedness, and also they can also pay attention to what needs to be completed in these pages. So in relation to Donees and replacement Donees, please take note that these are available at pages 3, 4, and 5 of the form 1 itself. Now, how does it look like? Let's look at the form now. At page 3 of the form, you will see that you have to complete the particulars of Donee 1. So if you only have one Donee, then you only need to complete this page. So again, you have to put in the particulars such as the full name of Donee 1, NRIC number, email address, contact number, and the relationship to the donor. So if it's your child, then you just put child. If it is your friend, you can just put relationship to donor as friend. Now, local mailing address is also important, and this part is what I like to highlight. What are the powers granted to this donee from you? Example, if only personal welfare, then you tick one box only, yeah? Because if it's personal welfare, you tick the first box. If this person is going to deal with your property and affairs only, you tick the second box. But if this donee is going to be able to deal with both your personal welfare and property and affairs, then you tick the third box. So please remember, tick one box only, and make sure you initial at the bottom right-hand corner to make sure that everything is in order. Well, page 4 is if you have a second donee, then you go through exactly the same process as what I've just described. And at page 5, this is an important page because it says the replacement donee's particulars. So similarly with your donees, you have to include the particulars of your replacement donee. Now, at the bottom part, again, is important. And this was what we had seen a few slides before. You have to tick one box only, what this replacement donee can do when he or she becomes the replacement donee. Is he or she only going to step in when, in particular specific situations, or is the replacement donee going to just step in as long as any of the original donees is unable to act? So again, as I said, that's the most flexible. If you like that to happen, then you tick the first box. Okay. Now, we will go on now to the next slide, or rather the next part, again on donees, specifying the powers of the donee. Now, the powers that are granted to the donees is covered in section 4 of Form 1. Now, in terms of personal welfare, in terms of property and affairs, it's actually all quite specifically stated there, or rather it's an elaboration of what are the powers that you as a donor would give to the donees. If you look at personal welfare, you will see, for example, do you allow your donees to give or refuse consent to continue treatments? You could be very, obviously you would have lost mental capacity, but will you want your donee to allow clinical trials? For example, there could be a new medicine that the medical professionals say it's worth giving it a try because you could recover from this if you go through this. So do you let your personal, for example, your donees allow the donees to make such a decision? Okay, yes or no. And if you have appointed more than one donee, with regards to personal welfare powers, you will also want to be very specific here whether or not they are jointly or severally or jointly, and which we already discussed that. Similarly with property and affairs, if you want any specific powers to be granted, look at it carefully and tick accordingly. So I think this page is something you may want to take some time to digest. Okay, now this particular slide is going to be, this slide, what does it not cover? So we talked a lot about the LPA, right? The LPA covers this, the LPA covers that, but what does it not cover? Now, the LPA does not cover overseas assets. That's one thing. It does not cover other areas that other instruments cover. For example, advanced care planning. For example, advanced medical directive. And you can read what these are, these instruments are, and also a will. That's important. And I want to emphasize that because a will handles matters after your death, right? But the donee cannot make a will for you. The will only comes into effect after you die. The LPA comes into effect when you are still alive, but mentally incapacitated. Now, the LPA also does not cover insurance nominations. It doesn't cover CPM nominations. Now, please remember this slide very well. And because it's so important, I'm going to ask Yuan Fei to translate this for you. What the LPA does not cover. Yuan Fei, please.
Okay, thank you, Kit. Yeah, so I will focus on slide 32 because I think that's really a key takeaway of this presentation. 所以刚才欧律师提到，持久授权书是不能概括一切的。因为你除了立持久授权书以外，你也要为别的东西做出一些筹谋。所以有些重点就是：第一，国外的产业不包括在持久授权书内；第二，预先护理计划、医疗护理授权书和遗嘱跟持久授权书是不一样的东西。我就拿遗嘱跟持久授权书来做个比较。比如持久授权书呢是您还在世却失去心智的时候，为你的失误做出的处理。遗嘱是你一个人死后财产的分配，所以是不一样的东西。然后第三呢，您的授权人被授权人不可以为您立遗嘱，他也不可以为您做保险受益人和公积金受益人的提名，所以这些事宜你都要亲自办理。Over to you, Kit.
Thank you, Yuan Fei. So. In terms of the next few pages, I don't think I need to, I don't have to go through very much on this. Basically, it's about signature, acknowledgement, and all this. So just very quickly, and we spoke about how the particulars need to be completed properly, and also at the lower right-hand corner where you have to initial as a donor, make sure you have your signature there. Now, the following pages 7 to 11 of Form 1 actually shows you, where you need to sign, and what are some of the powers granted to donees, and when you make a statement, the signature, each donee has to sign. So I just want to highlight a few points on these signature pages, or what we call acknowledgement pages 7 to 11. Now, for this one, donee 1, donee 2, pretty straightforward, but please make sure that there are witnesses. Now, the witness must also at least be 21 years old, and please, the witness cannot also be you. You cannot be your own witness, all right? And also, another donee or a replacement donee cannot be a witness as well. So you need to get an independent person to be your witness. So that's the thing I want to highlight for the donee pages. Now, the replacement donee pages similarly also has this witness box. So please make sure you get that signed. And if the witness is translated the form to you, please indicate and tick what was the language that has been used for translation. Very important. Now, last but not least is your signature and your statement. Now, I cannot emphasize this more because it's your LPA, and you want to make sure that it is firstly properly completed and more importantly, properly registered. Now, you sign on this box, all right? And then if this has been translated to you, make sure the translator also signs and indicates what is the language that he translated from. And this one, the signature of the certificate issuer. Remember, we talked about the CI as a certificate issuer, either being a lawyer who has a practicing certificate, or a medical practitioner registered with the OPG, or a psychiatrist who is a medical practitioner who is a psychiatrist. They have to sign here as a witness. Please make sure that this is properly signed as well. Now, you will see a fixed seal here. And this one, many of us go seal. What is a seal? And this really is just like a red sticker that you can buy from stationery shops. Most of the time, it's easily available. Right, Yuanfei? That is what we have seen in most situations. Just that red sticker, just buy a red sticker from the stationery shop and just affix the seal there. So it is actually signed and sealed, and then you deliver it to the OPG. Okay. Now, certificate issuer. Bear with me. I just want to emphasize one more time. In section 8 is also important for you when you go to your certificate issuer, and you see here I've described them just now. You look at it again. Medical practitioner or psychiatrist or an advocate, a solicitor who is basically a lawyer that has a valid practicing certificate. They need to sign here as well. In section 8, they got to sign here and affix their professional stamp. And many of them will have their own professional stamps. They will know what they are doing. They will know how to affix this stamp. So just recap, where does the CI sign? CI signs in section 8, and the CI also has to sign in section 7.1. Okay, I mean, from experience, there are some times when the CI actually misses out 7.1 and only signs in section 8, then it's an incomplete form. Okay, please, just something to bear in mind. And last but not least, your signature here, and as a donor, an applicant or LPA form 1, you have to actually also affix. If your donee wishes to be an applicant, he also has to complete the fields below. So that is basically the section on signatures, acknowledgement, and again, as I said, please be careful, look at the form properly. Where you need signatures, please make sure you obtain them and get them formally acknowledged. Yeah. So with that, I think we have
Q&A.
Yeah, we have.
Yeah,
and maybe just before the Q&A, and I can see that there are some questions that have come in. I just want to highlight that, if you have any further questions about the LPA, or you have any personal, situations that you want to clarify, you can always go on to the official website of the OPG's office, or you can call their hotline, or you can email them. So make sure that you go to the official channels to post your questions, and don't just, don't ask your friends, because your friends may not know better as well. So it's better that your friends and you go to the OPG, call them up and have a group call or something, to check. So it's important for you. And I know that this talk is quite short. What we are hoping to achieve here, Yuanfei and I, is just to promote awareness so that most of you will know what the LPA is for and why is it so important for us to have an LPA. This, again, whatever we said today doesn't constitute legal advice. We're not offering to represent you. We're not representing you. And if you have any information that you require and you choose to want to seek a lawyer, you should seek independent legal advice.
Okay, so there are quite a lot of comments that I can see here. So apologies if we can't address every single one of them, but I think I'll just kind of read out some of those that I see here, and we'll try to address them as well as we could during this period of time. So I think the first one for you, Kit, is what happens if husband and wife have a joint bank account, but one of them got dementia without making an LPA? So what happens in that instance?
Okay, so I'm sure many of us have bank accounts, and then if you're married, sometimes you have so-called joint accounts, right? And joint accounts, there are also different sorts of joint accounts. There are the and the same concept applies when we talked about joint and several, or joint, right? So joint bank accounts typically would require two holders to operate the bank account. So if your husband loses mental capacity and you do not have a donee in place, then it's likely that you will not be able to operate the account. As opposed to a bank account that is an and/or situation, then if your spouse passes away, then at least you as a survivor will be able to continue to operate the bank account if it is an and/or situation. So don't forget, just to emphasize, if it is a joint account, meaning an and account, then if your spouse passes away and you don't have a donee, then it's likely you will be unable to operate the account. So just be very careful, which is why we emphasize you should have a donee.
So essentially, you will leave the other account holder stuck as well.
Exactly.
Right. Okay. So that's great. Good information to know. I think the other question that came in, I see a lot of questions relating to Donees. I think there's a lot of interest around Donees.
Wow.
So one of the question is, if potential Donees want to learn more about Donee duties, what should they do?
Well, I think the shortcuts to all that is go to OPG's website, which is basically the official website. And, you'll be surprised. There's a lot of information there. It's very step by step. They tell you all the obligations as Donees, what are the responsibilities you have. So I think that there's a wealth of information there. So please go and check out the official website of the OPG, and you can find it there.
Yeah. And I think they also probably do some webinars as well. So good to have a check as well.
Yes. Absolutely.
Yeah. Okay. So there's just really quite a lot of questions. Okay, maybe another one. Yeah. Can Muslims make LPAs?
Yes. There's no reason why. So the LPA is basically open to Muslims and non-Muslims. So in respect of that, no issues. Muslims can make LPAs.
Okay. Then the other question that came in also is, can the OPG act against Donee for abuse of powers?
Okay, maybe for that we can talk a little bit about what are some of the safeguards, because of course you say, hey, I make my LPA, and then if my Donee abuses his powers, what do I do? Because I'll be mentally incapacitated. I can't possibly go after the person. There are many safeguards available, and not just the OPG per se. So under the Mental Capacity Act, there are safeguards. So as you mentioned, firstly, the public guardian has powers to supervise and also to investigate. And the public guardian can also apply to court to revoke the powers of the Donee in specific situations when that is required. Also, another thing that I should talk about in terms of safeguards is that there are also certain decisions which a Donee cannot make. Okay, so which we already touched on earlier, right? What a Donee cannot do or what it doesn't cover. Now, I think a lot of us are just concerned about what if my caregiver or my Donee abuses, their power, tortures or whatever, the person, or causes a lot of creates a situation whereby they are abusing their power. Now, if the Donee does that, actually the caregiver can also make a report. And there are also whistleblowing protection, which means to say that if you make a report or you provide notice for such situations, your identity will be protected. There's confidentiality that is attached to it. So you don't have to worry about that. You can provide that notification or to whistleblow. Now, the Mental Capacity Act also makes ill treatment of persons who lack mental capacity a criminal offense. So I think that is also an additional safeguard that the Mental Capacity Act actually provides to people who are worried that, hey, if I'm mentally incapacitated, if someone ill treats me, what happens?
Yeah. Okay, great. And there are a couple of more questions as well. I think some of them are more formalities and related, around, how do I get this done? I think there was one question, I think we mentioned about, Form 1 not being a necessity for lawyers to draft them. But I think there was also a question where someone was asking, but nonetheless, can I also just seek the assistance of a lawyer if I so choose to want to get one? Yeah.
Well, there's nothing to prevent you from approaching lawyers for anything you want legal advice on. If you are unsure about how to complete the form, or you just want a lawyer to explain it to you because you feel more safe, to better understand the process and what it's all about, by all means, you can go ahead and seek out a lawyer. But I think what we're trying to emphasize here is that Form 1 is actually, as I mentioned, very basic. It's supposed to allow the majority of people to understand. So there's really no need for you to go to a lawyer unless you want to. By the same token, there's nothing to prevent lawyers from giving advice on Form 1 as well, if someone consults them on the matter.
Okay, got it. So essentially, it's really to make it accessible for everyone, but there's always a choice for you to go and seek legal advice from that. Yeah. Then a couple of other questions as well. We'll try to take them. I mean, one of the questions that we have here was, which I think it's quite a good one. It says here, so it asks here, I see that LPA applies only when I have mental capacity. I saw it doesn't cover the will. So if I pass on, will the LPA be revoked? I'm focused on. After I pass on, can someone else on my behalf, can you advise? I think perhaps the audience is trying to understand the distinction between the LPA and the will, and I think this is a very important point that we should make clear.
Emphasize,
because there's always a little bit of a confusion, around where the parameters lie and how where they are. So I think it bears re-emphasis.
Yeah, so I guess we should just re-emphasize this part. The LPA only operates when you're still alive, but you have no more mental capacity. So that's where your Donees can come in to make decisions for you, whether it's in your personal welfare or your property and affairs. Now, if you die, unfortunately, in the situation where you die, then the will come into effect. So your LPA no longer has any bearing because you are dead, right? I mean, if you are dead, you are dead. Then the will then come into effect to take care of your property or assets that you used to own. Now, it makes sense, right? Because if you are dead, then there's no more personal welfare, so to speak, right? There's no daily needs or whatever it might be. So please differentiate the two. When you die, your will is the instrument that comes into effect to take over the distribution of your assets. And if you don't die, but unfortunately become mentally incapacitated, then your LPA will come into effect so that the Donees, the people you appoint to take care of you, will have the right to do so.
Okay, couple of other questions as well that I see here. I saw someone asking whether does the donee have to appear before the CI to get it signed? And I recall that this point has already been addressed on the MSF website, so maybe I can address this.
Yes, please.
The answer is it's not a necessity, but I think some CIs may require you to do so. Yeah. Because the key around having a certificate issuer is for them to basically assess your mental capacity of the donor when they're making the power of attorney, and to just make sure that you're not coerced or forced into making the decision. Yeah. I hope that was useful.
Yeah, and I think that on that note about the FAQs are available on the website, I think many of you should go there and have a look, because there are actually a lot of FAQs, which I can see that some of the questions here are there. So you can get all the answers there.
Correct.
Most of,
Yeah. So what we'll try to do with the span of time that we have here is I'm going to ferret out FAQs that perhaps might not be so easily available on the website. So it might be something that I think is of value for us to deliver to the audience. So one other question that I think it's something that I also hear people ask quite often. I think this is a valid question. If I don't have children or much assets, is there still a need to do an LPA?
So, I mean, to my mind, an LPA is not just about assets, right? I mean, as we have seen, there's the division of to personal welfare and also property and affairs. It doesn't mean that the LPA is only meant for people who are asset rich or are, what we call rich people. It's not. The LPA is supposed to be for every one of us, okay? Because it deals with your personal welfare. And that's why I think this is really a very good initiative. That was started, and it's definitely a good instrument for you to execute and register, because when you become mentally incapacitated, you can't make any decisions for yourself. And the last thing you want to do is for people who are there and are willing to make decisions for you, but they can't because you didn't give them the power to do so. So don't let your next of kin be stuck that way. It's very sad often when we see people who are mentally incapacitated. So as I always say, it's easier to die, right? But if you don't die and your people who want to help you cannot help you, so the LPA is meant to help you on that. So it doesn't mean it's for people who are just asset rich. Not true.
Okay. Yeah. Another question that has come in, and I think it's also something that is a good question. I think someone was asking if you appoint two donees but not joint donees. I think this person is referring to joint and several donees. Will priority be given to the first donee to make charge of all decisions?
The and/or situation, right?
I think they're talking about the and/or. So you appoint two, then is there like an assumption of who has priority in terms of the making of decisions?
No, I do not think that no, there's no favoritism or priority in terms of who should be the one that makes a decision, right? So for example, if both of them are your children, right? Again, like even for yourself, you will never be asked to choose your favorite child in that sense. So no, there are no specific provisions that says you must accord certain priority.
Okay, yeah. So the other question is, does the donee have to acknowledge? I suppose acknowledge, I think, means acknowledge by signing on the form, I guess.
Well, if that's the case, then yes, you have to sign.
The donee has to sign, correct.
And get it properly witnessed as well.
That's right, yeah. So let's see what other FAQs we have. We have quite a bit, so let me just ferret out some of those. So someone asked, where can you get an LPA and how much does it cost? I think we've sort of covered that just now, but maybe you would want to re-emphasize that point.
Well, the LPA, as we mentioned, is actually available for you to download from the OPG's official website, whether it's Form 1 or Form 2. So that is something which you can just download and print. But okay, fine. We shouldn't take for granted that everybody can do that. There are people who may not have access to such facilities. So you can actually get a copy of that physical form from the OPG's office. But I'm not so sure. Do check in with them about whether or not you can go there, because we are in the time of COVID. So you may want to just call up ahead of time to say, I would like to come down personally to collect a form. Can I do that? They may require you to make an appointment and then do your, bring your IC anyway, because you may have to scan in and all that. So just take the necessary precautions. Yeah.
I think they are probably closed for now. But there probably are some community areas where they might offer printing services for you to print off the net, from what I understand that to be. So
and in terms of the fees, as we mentioned earlier, so if you submit Form 1 and you are a Singapore citizen before 31st of March 2021, then it's free. So you don't have to pay anything. But if you are a Singapore citizen but you want to file Form 2, or if you are a PR or a foreigner and you want to file any of the forms, then you have to pay a small fee.
Yep. And then another question that came in is, what if the donee himself no longer wants to act? Is he stuck? Just like the donor can revoke the LPA, can change the mind. Can the donee change the mind? I think that probably is the essence of the question.
I think the donee definitely can change his mind or her mind. So as you can see, that the reason why we encourage people to have replacement donees in the first place is to cover situations like this. So if your original donee decides, oh, no, sorry, I just don't want, all right, I don't like you anymore, whatever, right? There could be many situations. Then that's where your replacement donee can step in to act on behalf of this original donee who no longer wishes to act for you.
I saw someone put in a clarification again. I think it's in further clarification to one of the points you made earlier. The comment reads as follows. Please re-clarify for joint and/or bank account. If one party is mentally incapacitated, doesn't mean the other party can operate the bank account as per normal. So I think we touched on joint accounts and joint and/or accounts. I think the audience is trying to seek a clarification around the operations of joint and/or account.
Are we assuming that there's an LPA that is formally registered and that there's a donee?
I would assume that there is no LPA. So I think the person is trying to understand, if I have two persons and one of them is mentally incapacitated and there's only one person left, and this is a joint annual account, can this other person operate the bank account?
Well, I think in the spirit of the fact that we are only talking about the LPA, we would address that only in the situation whereby there's an LPA. So as we mentioned earlier, if you have an LPA and there's a donee, so it wouldn't matter if the donee, even if you are mentally incapacitated, because the donee can step in. Now, if they are taking an opportunity like this to ask about, how the banks would decide, then I would maybe strongly suggest that they call up the bank and discuss if it's a non-LPA situation.
So someone who asked about the mom being in an early stage of dementia, but she hasn't actually gotten a certification done by the doctor. So are there any alternatives for her since she can't do an LPA? Yeah. So she's just checking about that.
That's a very tricky, I mean, not tricky in a sense, but it's very, very difficult question, because if she's not certified to be medically, unwell, i.e. she has got dementia, I think what situations like that, if you cannot do the LPA for her, or rather if she cannot do the LPA for her, then unfortunately the LPA wouldn't be an instrument that will be that she can execute. Then you will have to consider other alternatives, whether or not you may need to, become a deputy, as in like you may have to go to court for certain orders that the court will have to make for you. But again, as I said, in situations like this, it might be useful for you to consult together with the medical professional to see what's the best situation, because sometimes dementia can be in various stages, in early stages or different situations. So if the doctor says, check with the doctor all the time, and if gradually, your mother becomes better, she might be in a position to make an LPA, then that's when you can actually try to get it done.
Yeah. So another question that came in as well: can you get one of the Donees to be a replacement Donee? So I think probably there's maybe you might want to re-emphasize the distinction between the original Donee and the replacement Donee.
It would not be possible, because they are not the same, and they are supposed to be completely different people, in the sense that, so if you have an original Donee and that person refuses to act or cannot act anymore, that's where the replacement Donee comes in. So the original Donee cannot possibly replace, himself, right? In that sense. So they are very different people. So please make sure that they are different in that sense. Yeah.
Yeah.
There was another question.
There were a couple more questions here.
There's one question that I saw, and it says, what are the typical amounts of fees to pay to the certificate issuer? Unfortunately, I don't have any visibility on that. I guess the other question is there a fee to pay to get a certificate issuer's signature? Again, it depends on who you approach and whether or not they charge a fee. So, I mean, obviously, if you are seeking the advice from somebody, from a lawyer or medical professional, and if they charge a fee, then you will have to honor that fee. But I don't have any visibility on that from a. I don't. Yeah.
Yeah. So another question that came in: if I need to cancel or make alteration in my LP after a year, do I need a medical certification to confirm that I'm mentally okay?
You would have to have mental capacity for purposes of revocation. We talked about that earlier on. Now, to make amendments,
I think they probably just submit the revocation form, right?
Yeah, and do a new LPA. But regardless, in all those situations, you must be mentally capable, because otherwise you are not able to do any of that.
Yeah.
Yeah.
Oh, someone had a question that says, if two joint Donees doesn't agree, how will decision proceed?
If you're talking about joint Donees being together have to make one decision, right? In that scenario, whereby our boy and our girl both must agree. Otherwise, if they don't agree, then unfortunately your LPA will not be operated. No decision can be made, so you're stuck.
And I think that's probably why we emphasize that there are pros and cons to getting a joint and several and joint Donees, joint and several, having that flexibility, the joint being for people who are a bit anxious with having one person having that sole decision power. So it is a toss-up between what you wish to achieve.
I think people must sometimes have to be more practical. I mean, you love your children equally and everything, but it doesn't mean that when it comes to life decisions, you have to, in a way, you might burden them rather than help yourself, in a sense. So coming back to it, no matter what you do, how you decide, make it as flexible as possible. don't make it overly restrictive, because then otherwise it defeats the entire purpose of having the LPA in the first place. Yeah.
Yeah. Another question that just came in: does the donee need to be informed that I want to make him or her my donee?
I think that's a very obvious answer. They have to sign, right? I mean, so you will have to inform them what they are signing and what powers they will have. So I think the answer is a definite yes. Yeah. So this is I mean that part about whether donees need to be informed and need to know about it is something which I see quite a few people asking. So maybe we can holistically put it out as they need to sign, so therefore they will need to know. So that's part. Yeah. I saw another question that is quite interesting. It says that I have difficulty filling up the complicated form and executing it. Can't it be made more simplified for seniors? To be very honest, I think this new form, the 2020 version, is already simplified, which is why I say that if you have any questions that you want, you can actually call up the OPG's office. And I understand that sometimes they will take their time to go through it for you if you have any difficulties. So call them up and see what happens. And also, as Yuan Fei mentioned in the earlier part of our talk, there are many talks that OPG organizes. So you can always go for more talks until you are very familiar, and then you can ask any questions along the way. Yeah, but it's already quite simple. Yeah, I think.
So I think there are some people who ask about list of CIs and where do you get them?
The OPG maintains a list of the medical professionals that are on there. I believe that is on the list on OPGs. But if you want to know who are advocates and solicitors, i.e. the lawyers with a practicing certificate, you can also go onto the website. I believe it's the Law Society. One second. I think it's the Law Society's website, which lists out the lawyers in Singapore who have a practicing certificate. You can go to the Ministry of Law's website. They have e-services, which is under the LSRA. They have an integrated website which lists all the lawyers that have practicing certificates in Singapore. So you just go there and choose, not choose, but you can go there and at least you know who have practicing certificate. I believe the Medical Society will also have a similar website.
So I think we probably have time for one last question. So maybe I could just see one of the questions. I think someone was asking, can a donee be a recipient of my estate?
Are you talking about after you die? Because after you die, your will takes over, and whoever.
No, I suspect that the audience is probably asking, let's say, for example, if I appoint a donee under LPA, can that same person who's acting for me in an LPA situation also probably be a beneficiary of my will?
Well, why not? Because they govern different things, right? The LPA is when you're alive, and if you die, your will takes over. So, for example, if your donee is your son, you would definitely leave some. I mean, you in all likelihood would leave something of the estate to your son. So yes, you can.
Okay, so I think we've probably come to the end of the session, because so apologies. I think we do have quite a lot of questions. We've tried to answer most of them, but because of the time constraints, we might not be able to answer everything. But thank you for your questions. And if there's any good feedback, we will also take them on board. And maybe at this juncture, I would like to just share with you this particular slides, because obviously in any kind of talks, we will try our best to cover everything, but there will be particular issues or questions that you feel burning, or that might just have sparked a thought, and you might want to get a little bit more clarity. There are always websites and phone numbers that you can reach out to understand a little bit more. And I also would like to just take this opportunity to just ask that if you like what we've presented today, and you feel that you have some other people who may benefit from knowing a little bit more about the LPA, and that they should also take the initiative to get one done, please like and share, and so that we can bring the message out to more people and help them. So I would like to also thank C3A for the opportunity to share what we feel is a very important message. And just also thank you to the audience for spending a wonderful afternoon with us. And we hope it has been useful. Yeah, thank you very much.
Thank you. Thank you, everyone. Stay safe.